The 10-teller million mistake that started with a simple slip and fall a wet floor, a few careless steps, and a moment that lasted less than 2 seconds. At first, it looked like the kind of accident people laugh off. No dramatic crash, no viral footage, just a simple slip and fall inside an ordinary business. But what happened next would trigger years of legal battles, intense investigations, and a payout worth nearly $10 million. The shocking part? The money wasn't awarded because someone slipped. It was awarded because of what happened before the fall and what happened after it. In personal injury law, some of the most expensive cases begin with accidents that seem completely insignificant. And this case reveals exactly how one overlooked mistake turned a routine incident into a multi-million-dollar disaster. Continue. Most people hear the words slip and fall and immediately think of a minor accident. Maybe a bruised knee, maybe a sore back, maybe an embarrassing moment that becomes a funny story later. But in the world of personal injury law, some of the largest settlements and verdicts in American history have started with exactly that kind of incident. Not because slipping is inherently catastrophic, but because a fall can expose something much bigger: negligence. And that's where this story begins. Imagine walking into a business you've visited dozens of times before. Nothing seems unusual. The floors are clean. Employees are moving around normally. Customers are coming and going. Then suddenly, your feet disappear from under you. 1 second you're walking, the next you're on the ground. For many businesses, that moment represents more than an accident. It represents a legal question. Could this have been prevented? That single question often determines whether a case ends with a denied claim or a multi-million-dollar payout. In personal injury law, property owners have what's known as a duty of care. In simple terms, they are expected to take reasonable steps to keep visitors safe from foreseeable hazards. That doesn't mean every accident automatically makes a business responsible. People trip over their own feet. People ignore warning signs. People make mistakes. But when a dangerous condition exists and the owner knew, or should have known, about it, the situation changes dramatically. Now let's consider a common example. An employee notices liquid on the floor. Minutes pass. Customers continue walking through the area. No cleanup occurs. No warning sign is placed. No action is taken. At that point, the legal issue is no longer the spill itself. The issue becomes the decision to leave the hazard there. And that distinction is incredibly important because juries don't just evaluate injuries, they evaluate behavior. They ask questions such as, how long was the danger present? Who knew about it? What reasonable steps could have prevented it? Why weren't those steps taken? These questions often become the foundation of a negligence claim. But here's where many people misunderstand slip and fall cases. The biggest financial losses usually don't come from the initial injury. They come from the consequences that follow. A fractured hip can require surgery. A spinal injury can require years of treatment. A traumatic brain injury can create lifelong cognitive problems. A person may lose the ability to work. Medical bills begin accumulating. Income disappears. Future earning capacity may be permanently reduced. Suddenly, what looked like a simple accident becomes a life-changing event. And when attorneys calculate damages, they're not only looking at today's expenses, they're looking at tomorrow's costs as well. Future medical treatment, rehabilitation, lost wages, pain and suffering, permanent disability, loss of quality of life. These damages can reach staggering amounts, especially when the victim is young or faces decades of future challenges. Now add another factor that often changes everything: evidence. In modern personal injury litigation, evidence can determine the entire value of a case. Security cameras, maintenance logs, cleaning schedules, internal emails, EE statements, incident reports. What seems like routine paperwork can become critical courtroom evidence. Imagine investigators discover that employees reported the hazard multiple times before the accident. Imagine surveillance footage shows people nearly slipping throughout the day. Imagine management knew there was a recurring problem but delayed repairs because they wanted to save money. Suddenly, the narrative changes. The case is no longer about bad luck, it's about preventable negligence. And juries tend to react very differently when they believe an injury could have been avoided. This is one reason why insurance companies aggressively investigate serious premises liability claims. They know that if evidence suggests a property owner ignored known risks, potential damages can increase dramatically. In many cases, insurers attempt to settle before a jury ever hears the full story. Because once a jury becomes convinced that warnings were ignored and safety was sacrificed, verdicts can escalate rapidly. What begins as a dispute over a fall can evolve into a broader examination of corporate responsibility. Did the company prioritize safety? Did it follow its own policies? Did it take reasonable precautions? Or did it choose convenience over prevention? Those questions often become far more expensive than the original accident itself. And that's exactly what happened in one of the most costly slip-and-fall cases ever examined. What initially appeared to be an ordinary fall soon revealed a chain of decisions, missed warnings, and overlooked responsibilities that transformed a routine insurance claim into a legal nightmare worth millions. And when investigators started digging into what the company knew before the accident occurred, the story became far more damaging than anyone expected. As the case moved forward, what initially looked like a straightforward injury claim became something much larger. The attorneys representing the injured victim weren't focused solely on the fall itself. They focused on the evidence surrounding it. Every maintenance record, inspection report, employee statement, and internal communication was examined. What they uncovered painted a troubling picture. The dangerous condition wasn't a sudden, unavoidable hazard. Evidence suggested that the risk had existed long enough that reasonable action could have been taken to prevent someone from getting hurt. More importantly, questions began emerging about whether warnings were ignored and whether safety procedures were properly followed. That's the moment when the value of the case changed dramatically. In personal injury law, juries often understand that accidents happen. What they struggle to accept is preventable negligence. When a business has an opportunity to fix a known danger and fails to do so, the conversation shifts from bad luck to responsibility. The injured victim's legal team argued that the injuries weren't merely painful, they were life-altering. Medical expenses continued to grow. Treatment and rehabilitation became ongoing realities. The victim's ability to work and enjoy daily life was significantly affected. When damages are calculated in cases like this, the numbers extend far beyond the emergency room bill. Courts and juries may consider future medical costs, lost earning capacity, physical pain, emotional suffering, and the long-term impact on a person's quality of life. Over years or even decades, those damages can reach extraordinary amounts. That's how a seemingly ordinary slip-and-fall incident can evolve into a case worth millions of dollars. And that's the lesson many people miss. The $10 million mistake wasn't the fall itself. The mistake was allowing the conditions that led to the fall to exist in the first place. A wet floor can be cleaned, a broken handrail can be repaired, a dangerous hazard can be marked with a warning sign. These are often simple, inexpensive solutions, but when they're ignored, the consequences can become devastating, not only for the victim, but also for the business facing the legal and financial fallout. This case serves as a reminder that personal injury law isn't about rewarding accidents. At its core, it's about accountability. It's about determining whether someone failed to take reasonable steps to protect others from foreseeable harm. And sometimes, a single overlooked hazard can expose a chain of decisions that ends with a verdict or settlement worth millions. Because in the eyes of the law, the most expensive mistakes are often the ones that could have been prevented. If this story surprised you, You're not alone. Many of the biggest lawsuits in America started with situations that seemed completely ordinary at first glance. So here's the question: do you think businesses should be held fully responsible for preventable accidents, or should individuals carry more responsibility for their own safety? Share your thoughts in the comments. We read every one of them. And if you enjoy real legal cases, shocking lawsuits, and the hidden stories behind multi-million-dollar verdicts, make sure to subscribe and turn on notifications. Every week, we break down the cases that reveal how one decision, one mistake, or one overlooked warning can change lives forever.